Welcome back to the deep dive. We've got the stack of sources you sent in, and today we're doing a deep dive into something. Well, something fascinating and, frankly, a bit terrifying in Costa Rican family law. So let's set the scene. Imagine you're an international traveler. Maybe you've spent time in Costa Rica, started a family, or you're dealing with a separation there. You're at the airport, you've got your boarding pass, and you get to the immigration desk, and they stop you. They just say, you cannot leave the country. And the reason? A travel restriction, all because of a family support lawsuit. We're going to dig into what the sources call this peculiar law, how it really works, and most importantly, the 3 guaranteed legal ways out.
That's exactly right. And for anyone navigating these cross-border family issues, this isn't just, interesting legal theory. It's operationally critical. So
Yeah.
our mission today is really threefold. First, to understand the mechanism itself. Second, to look at this huge legislative shift that happened in late 2024, which completely changes the game. And third, we need to detail the practical steps, the actual methods to get that restriction lifted legally and quickly.
Okay, let's start with that core law because the shock factor is huge. It disproportionately hits people living abroad who had relationships in Costa Rica. The basic idea, I guess, is that the country wants to make sure you're going to pay child support or alimony before they let you leave their jurisdiction.
Exactly. And what's really interesting is how it's implemented. It's not a physical thing. It's all digital.
Yeah.
The moment the family court places that restriction, your ID number, your name, it gets flagged in the main immigration computer system. So if you try to leave, doesn't matter if it's the main airport in San Jose or a land border, the system flags your passport. You're stopped.
And the immigration officer can't do anything.
Nothing. They can't override it. They're just enforcing a court order. So you are literally grounded until the court says otherwise.
That sounds terrifying, honestly. To be tied to a computer system in another country, is there any way to check your status before you even try to fly? Or do most people find out at the airport?
That's the tricky part. The sources suggest it's not always transparent. You generally find out when you try to leave. But the system does rely on formal notification. So if you've been served with court papers for a lawsuit, you have to assume that restriction process is underway.
Do you need a lawyer?
You need a lawyer to check the court file directly. That's really the only way to know for sure. And that uncertainty is why the timing is so important.
And that's where this big change in late 2024 comes in. Before that, it was pretty brutal.
It was. Before late 2024, the restriction could be placed almost automatically. The moment the lawsuit was filed, boom, you could be trapped.
So you could fly in for a week, get served papers, and suddenly you can't go home.
Right. Before a judge had even decided if you owed anything or how much. The new structure, though, it adds a mandatory buffer. Now the court must schedule an initial hearing. In Spanish, it's called a conciliation. It's basically a settlement meeting.
Okay, so what's the strategic difference there? What does that hearing change?
It changes everything about the timing. The travel restriction can now only be placed after a monthly payment amount is formally decided. They call it the anticipated sentence. And that's only set one of two ways. Either you both agree on an amount in that hearing, or the court steps in and orders a specific amount.
Uh-huh. So this sounds like a massive tactical advantage. If I fly in for that hearing and we don't reach an agreement,
Then the amount isn't set yet.
which means the restriction isn't active yet, is that right?
That is absolutely correct.
Yeah.
If that hearing ends without a formal agreement or a court order setting the amount, you have this critical window. You can potentially fly back home before the restriction is activated. It really shifts the power dynamic. The restriction is no longer just an automatic trap. It only kicks in after there's been a real judicial look at the finances.
Okay, but let's be realistic. Attending that hearing from abroad is a big deal. Flights, time off work. So if you miss that window and the court sets the amount without you, you're stuck.
You're stuck, and that's when you need to know the escape routes.
So let's transition to that. The restriction is in place. What are the 3 approved, totally legal ways to get out of the country?
The sources lay out 3 clear paths. Method number 1 is the simplest, but it's often the most impractical in messy situations. It's beneficiary permission. This just means the person receiving the support, your ex-partner, for example, goes to the court and asks them to lift the restriction.
And why is that so impractical?
Well, think about it. They hold all the cards. They have zero incentive to let you go unless there's a huge amount of trust, which is pretty rare in these cases. They can ask for it to be lifted for just one trip, for 10 days or indefinitely. But even then, they can just go back to the court and have it put right back on if a payment is late. It relies on cooperation.
Cooperation, that's probably not there. Okay, so that brings us to the method most people actually use, the guaranteed deposit. This is the financial route, but it sounds like you have to get the math and the paperwork perfect.
Precision is absolutely vital. You have to deposit a large sum of money into the court's bank account. It's a guarantee. It's not a payment you lose.
It's insurance for the court.
Exactly. It ensures that if you leave and stop paying, there's a pot of money for the beneficiary. And the baseline calculation is that this deposit must cover 12 months of support payments.
12 months is the baseline. But the sources mention mandatory bonuses that can increase that. What are those?
Right, this is a key detail. When children are involved, you almost always have to cover the aguinaldo.
Which is?
It's the mandatory Christmas bonus in Costa Rica. It's like a 13th month salary. So once you add that in, your guarantee is now for 13 months of support, not 12. And then on top of that, the court might also require you to cover something called the salario escolar.
School supplies.
Basically, the school expense bonus paid in January. If the court adds that, your total guarantee could be as high as 14 months of support payments.
14 months of your money just sitting in a court account so you can travel. That's a huge amount of cash to have on hand. But let's talk about the number one mistake people make here. The sources are very clear about this. You have to label that deposit correctly.
This is the critical procedural trap. When you make that transfer, usually to the Bank of Costa Rica, the deposit slip or transfer notes must clearly state that this is a guaranteed deposit to leave the country, or the specific judicial term.
What happens if you just label it ordinary deposit?
The court will interpret it as a gift.
A gift.
Or just a regular monthly payment. It will not count as the legal travel guarantee. Your money is gone, in a sense, credited to the beneficiary, and the travel restriction stays firmly in place. You lose the benefit entirely.
That's incredibly unforgiving. Wow. Okay, so let's say you get the 14 months of funds together, you label the deposit perfectly. What's the last step?
Once that money is secured, your lawyer provides the court with a deposit slip and a formal letter. The letter just needs to detail your trip, the dates, the purpose. And the good news is, once the guarantee is verified, the courts usually move very fast. Often within 24 to 48 hours, they issue the order to immigration to lift the restriction.
Okay, so that leaves path number 3 for people who just don't have 14 months of cash lying around. What's the last legal option?
The third option is to buy an insurance bond. It works just like the cash deposit, but instead of putting up your own money, an insurance company guarantees the amount to the court.
So the insurance company is on the hook if you default.
Exactly. They guarantee the court that they will pay out the 12 to 14 months of support if you disappear. The key difference here is the cost. You're not getting this money back. You pay a non-refundable premium to the insurance company. The sources suggest it's usually around 10% of the total guarantee amount.
So on a $100,000 guarantee, you'd pay the insurance company a $10,000 fee.
That's right. You save your liquidity, but you have a definite expense. Companies like the National Insurer, INS, or private ones like Oceanica offer these bonds.
So method 2, if you have the cash, method 3, if you don't. That covers the legal routes. And we should probably just stress the sources are very clear that trying to sneak across the border to Nicaragua or Panama is a terrible idea.
Absolutely. A very risky strategy. These legal procedures are there for a reason, and they work.
So if we bring this all back, the whole system is really designed to force you to engage and secure your financial obligations.
That's it. So the key takeaway for you, the listener, is really twofold. First, that post-2024 change in timing around the conciliation is your biggest strategic asset. Know that timeline. And second, if you do need a financial guarantee, you have to understand the math. It's not just 12 months. It could be 13. It could be 14 with the aguinaldo and salario escolar. That knowledge is the foundation of your entire strategy.
And that's exactly the kind of precise, actionable knowledge we wanted to pull from your source material today, taking a complex, really high-stakes situation and boiling it down to the legal mechanics and the numbers you need to know.
And it leaves you with a really interesting final thought to consider. How do different countries use the restriction of a fundamental right, the right to travel, to enforce financial obligations that cross borders? What kind of global precedent is this setting for making sure international support payments are, well, functionally mandatory?
Something to think about. We'll see you on the next deep dive.